Trump visa freeze, the 4 ways you could still get into the United States. If you watched my last video, you know that the Trump administration has now frozen immigrant visa processing for over 75 countries. And it's not just those 75 countries. There was another list preceding that one, a separate State Department announcement that suspended visa issuance for nationals of certain countries entirely for national security reasons. I've got links to both of these State Department announcements in the description. So if you're from one of these countries, you're probably wondering, what do I do now? Is there any way to get into the United States? Or let's say that you have applied for a spouse, family member, or employee. What are you supposed to do about their case now? Is my dream of coming to the United States just over? It's not. There are still legal pathways, but you need to understand the strategy has changed and you're going to need to act intelligently. In this video, I'm going to walk you through a few things. Number one, the overall meta that still works even with these visa freezes. Your 4 main visa options ranked from best to worst. Which visas to allow you to travel freely and which ones may trap you or may be less safe options. And lastly, what do you need to do right now, even if your interview is after January 21st? Hi, I'm Jake. I'm the head attorney and founder of Visa Law Group, top-rated immigration law firm in the state of Utah. If you need help with your immigration to the U.S., there's a link in the description of this video to fill out a pre-qualification form. Let's get into it. All right, just as a high-level overview, I want to remind everyone that this freeze targets immigrant visas, the visas you get from a consulate abroad that allow you to come to the U.S. as a permanent resident. That's what's frozen. Non-immigrant visas, temporary visas, are not frozen. So the standard way that U.S. immigration law expects foreign nationals to obtain immigrant visas is through consular processing. This is where you file an immigrant petition. You complete something called a DS-260 form. It's the State Department's immigrant visa form. You attend an interview at your U.S. consulate in your home country. You receive an immigrant visa in your passport, and you come to the United States with a sealed packet. And that's the documentation that you give to the Customs and Border Protection officers at the airport. And then you get your green card in the mail after you come here. That's like the standard way the law was built to allow people to obtain green cards. In reality, in 2026, there's a much more popular path that is more often pursued than not, and that is a process called adjustment of status. Adjustment of status, you'll likely hear the term AOS, is the process of applying for a green card while you're already physically present in the U.S. on a temporary status. To apply for adjustment of status, you file a form called an I-485 with U.S. Citizenship and Immigration Services. You don't do anything with an embassy abroad. And if this I-485 is approved, you become a permanent resident without ever needing to go through consular processing. To be honest, that is the most common path that people apply for presently, much different than what was originally intended. So the overall strategy to this is step 1, to enter the United States physically on a non-immigrant visa, a temporary visa, whether that is tourism, study, work, etc., that allows you to legally be present in the U.S. In a perfect scenario, you would want to pursue a non-immigrant visa that allows for immigrants' intent, meaning as a condition of that visa, you are allowed to want to immigrate to the U.S. Ideally, this visa would also allow you to legally work in the U.S. So the idea behind immigrant intent is that you could communicate to a consular officer or a Customs and Border Protection officer or a USCIS officer that you actually intend to immigrate to the United States as a condition of your non-immigrant visa, and that would not prevent you from getting this visa. This is definitely the exception rather than the rule. This only applies for very few visa types. Otherwise, the default position is that if you do intend to immigrate to the U.S., meaning if you intend to come to the U.S. permanently and not to return to your country abroad, the consular officer or the Customs and Border Protection officer or a U.S. Citizenship and Immigration officer will be well within their rights to deny your application. So once you obtain a qualifying non-immigrant visa that allows for immigrant intent, you may safely apply for an immigrant visa petition. Now, if you have a non-immigrant status that does not allow for immigrant intent, that does not prevent you from obtaining or applying for an immigrant visa, but you should be well aware that this does greatly increase your risks in applying. Heaven forbid, if your underlying immigrant visa petition is denied, it could have negative consequences for your underlying non-immigrant status. Again, depending on what that underlying status is. All right, so step 1 is to enter legally on a non-immigrant visa. Step 2, once you're here, is to file for an immigrant visa petition. This could be an I-130 petition if you're applying for family, an I-140 petition if you're applying based on employment, an I-526 petition if you're applying based on investment, or an I-360 petition if you are a special immigrant. All right, step 3, once that petition is approved or once your priority date on that petition is current, you can technically apply for adjustment of status. This is where you file the I-485 form from inside the US. Essentially, if you follow this process, you can bypass consular processing entirely. You never need an immigrant visa from the US consulate abroad, and you can get your green card from inside the US. In fact, that is a required condition. You cannot file the I-485 form if you are outside the US. Overall, high level, that's the strategy. Get in, get legal status, adjust status. This process, this strategy only works if you can get into the United States legally and lawfully on a qualifying non-immigrant status in the first place. And I'm going to walk you through, in my opinion, what are the best options for that. All right, one point I want to touch on earlier that I didn't touch on sufficiently in the previous video. Let me tell you what you need to do if you have an immigrant visa interview scheduled abroad. If you have an immigrant visa interview scheduled at a U.S. consulate, even if that interview is after January 21st, please make sure you attend that interview. I know it sounds counterintuitive. You're probably thinking, why in the world, if I'm not going to get approved, would I even bother going to this? The purpose is, if you don't show up to your scheduled interview, the consulate could potentially cancel your underlying petition, whether that's your I-130, your I-140, etc. You don't want to have that issue. So that petition took time, it took money, and most importantly, that petition has a priority date that's tied to it. Meaning, if you have to refile your petition again because you have had it canceled, you're going to have to get a new priority date. It's basically like getting back in line from the beginning. That sucks. We don't want to do that. So yeah, just make sure you attend the interview. Yes, adjudication may be paused indefinitely. That is true. That's a part of the State Department announcement. And they're likely not going to issue your visa that day or for a while. But the petition to stay alive, your place in line stays protected. When the visa freeze eventually lifts, these things are not going to last forever. You want to be able to still maintain your priority dates and maintain the availability of that petition. Let's talk about your options for lawfully entering the U.S. on qualifying non-immigrant visas so that you can pursue the adjustment of status strategy I described. I'm going to personally rank these on my favorite from best to worst. Reasonable minds can disagree. I'm just going to give you my opinion. All right, option number 1 would be O1 visas. If you can qualify for it, the O1, in my opinion, is the best option right now. Let me explain why. So, high-level overview, the O1 visa, whether that's O1A or O1B, for individuals with extraordinary ability in their field. So there are 2 types. O1A is for people with extraordinary ability in science, education, business, or athletics. You can think of researchers who've published extensively, successful entrepreneurs, high-level athletes. I personally use these visas very often for entertainers and clients who are social media influencers and high-level professionals. Those are the biggest ones for me personally. I love the O1A. O1B is for people with extraordinary ability in the arts or motion picture or television industry. You can think of these as musicians, actors, directors, visual artists, designers. All right, let's talk about why the O1 is such a great option right now. Number 1, there's no lottery. Unlike the H-1B, there's no random selection process. If you qualify and your petition's approved, you get the visa, period. There's no element of luck involved. Number 2, there is no $100,000 fee. Perhaps the biggest roadblock in applying for H-1B right now, the reason that's not higher on this list, is that the H-1B has this registration fee that's $100,000 if you're applying from abroad. There are a few exceptions to the H-1B $100,000 rule I won't get into in this video, but regardless, the O1 has no such fee. There's standard filing fees that apply. A base filing fee for an O1 visa right now is $830 as of January 2026. Premium processing for this is $2,805 extra. All of these are likely to go up. In fact, the premium processing fee is going up on March 1st. That is still significantly less than $100,000 plus the additional filing fees for an H-1B. Number 3 reason I love the O1, there's no 1-year employment requirement. The L1 visa, I'm going to talk about that next, requires you to have worked for a company abroad that has a qualifying relationship for at least 1 continuous year. The O1 has no such requirement. You can be hired by an American employer directly. Number 4, the O1 visa is not country specific. Some visas, you could think the TN for Mexico or Canada, or E3 for Australians, or even E1 or E2, the investment visas for people from treaty countries. These are, again, only available for certain nationalities. The O1 visa is available to everyone regardless of their nationality. Number 5, there's great flexibility in who petitions you. If you don't have a traditional employer, the O1 allows you to work with an American agent who sponsors your petition. So this is particularly helpful for freelancers, artists, entertainers, YouTubers, etc., and consultants. So you can essentially work for multiple companies while still compliant with the O1 visa requirements. The big question is, do you qualify for an O1? The O1 does require you to demonstrate extraordinary ability. I'm not going to sugarcoat that. But you don't need to be Elon Musk. You don't need to be Albert Einstein or a Nobel Prize winner. That's a very common misconception. What you do need to show is that you meet at least 3 of the following 8 requirements and show that you have sustained national or international acclaim. Again, this is for O1A specifically. If you have received awards or prizes for national or international excellence in your field, if you hold memberships in organizations that require outstanding achievement, if you are the subject of published material about you in major professional or trade media, if you have served as a judge of the work of others in your field, if you've produced original contributions of major significance in your field, if you've authored scholarly articles in major professional or trade media, if you've received high salary or remuneration compared to others in your field, or you will receive high salary or high remuneration, you can qualify for an O1. I've personally helped clients from all over the world to get O1 visas: software engineers, entertainers, researchers, entrepreneurs, dentists, lawyers, musicians. It's much more attainable than you likely believe. If you think you might qualify, talk to an attorney. I mean, none of these are rocket science, essentially. I also think it's quite possible for most people who are high-level professionals or highly accomplished in their fields to satisfy at least 3 of these 8 requirements. It's, at the very least, it's worth exploring in this environment. Now, the O1 is not truly a dual intent visa. The Foreign Affairs Manual does say that you can have intent to immigrate to the US. That's not a disqualifying factor for an O1. It's not truly dual intent in the sense that if you leave the US after you have filed adjustment of status, but before your green card is issued or before you have received an advanced parole document, a travel permit that lets you leave, your underlying adjustment of status will be considered abandoned. That is not the case for an H-1B or an L-1 visa. That's a very important distinction. However, ultimately in practice, the O-1 does allow you to pursue permanent residence without it automatically invalidating your visa. That is, if you apply for an I-130 or I-140 and you communicate to USCIS that you intend to immigrate here because you're applying for an immigrant visa, that will not invalidate your underlying O-1 in the event that that underlying petition is denied. Again, your mileage may vary. That's been my experience with dozens of successful cases with O1s. Bottom line, if you have this high-level achievements, recognition, or expertise, the O1 might be your golden ticket right now. That's what I would look at first. All right, the second best option for a non-immigrant visa to consider if you want to consider applying for adjustment of status is the L1 visa. The L1 visa is an intercompany transferee visa. It's designed for employees of multinational, international companies who are being transferred to an existing or new American office. There are basically 2 types of L1 visas. L1A is a non-immigrant visa for managers and executives who are being transferred to the U.S. to manage a U.S. operation. L1B is for employees with specialized knowledge of the company's products, services, or procedures. Let me tell you why an L1 is a great option potentially for you. Number 1, the L1 visa is a dual intent visa. The L1 explicitly allows for immigrant intent. This means you can apply for a green card while in an L1, and you can travel in and out of the country while your adjustment of status, your I-485, is pending without needing an advanced parole document. This is actually a huge reason why many applicants do not like adjustment of status. It's because depending on the length of time that USCIS takes to process your case, it could be more than 1 year. It could be more than 2 years in some rare cases, in my experience, for adjustment of status to process. And if you need to travel internationally, whether that is for employment or family, whatever reason it is, that can be a difficult pill to swallow. The number 2 advantage of an L1 is that there's, like the O1, there's no lottery. There's no random selection. If you qualify and the petition's approved, you get the visa. Number 3, no $100,000 fee. Again, just like the O1, standard filing fees apply, but it's not like the H-1B $100,000 fee. for employers filing from abroad. Just to be really honest with you, the L1 does have its limitations. It does have its difficulties in getting approved. Limitation number one is that you have to have worked for a foreign company for at least one continuous year within the last 3 years. If you haven't been with this foreign company for at least a year, you're not going to qualify. Just period, end of story. It's not going to work. Limitation number two is that the foreign company that you have worked for this continuous year must have a qualifying relationship with an American company. So let me say that one more time. The U.S. company and the foreign company that you have been working for at least 1 year within the last 3, they have to be related. That is, they need to have a relationship of a parent company, subsidiary, branch, or affiliate. You can't just have a random American company sponsor you for you to get an L1. Limitation number 3 is that new office L1s are quite difficult to get, just to be really honest with you. If your U.S. office is brand new, meaning that it's been in existence for less than 12 months, the L1 petition is going to face higher scrutiny, and the approval of the visa is only going to be valid for up to 12 months. You're going to need to show a detailed business plan, proof of physical office or premises, evidence of your ability to support the L1 transferee, and more. Just in my personal experience, the smallest company I've had that has successfully gotten an L1 had 6 employees abroad. That's just been my personal experience. There's no specific number of what it needs to be. If you work for a large international company and you're looking, or you're an entrepreneur, you own an international company and you want to start a branch here in the US, the L1 may be a great option for you. Just something to consider. Option number 3, we've come to it. We're going to talk about the H-1B visa. This is the most well-known work visa in the US, the most popular visa of topic on X/Twitter. It's a good time, the H-1B visa. For those of you who may not know, the H-1B is a temporary, a non-immigrant visa for workers in specialty occupations. You think of this as jobs that require at least a bachelor's degree in a specific field in order to perform it. High level, you would think of this as like engineers, software developers, accountants, architects, doctors, etc. All right, let's talk about the good news if you are going to do an H-1B. It is a dual intent visa. It is the dual intent visa. The H-1B explicitly allows for immigrants' intent. So you can apply for a green card or have a green card application pending and still maintain your H-1B. Like the L1, you also can travel internationally while your adjustment of status, your I-485 form, is pending without needing advanced parole, this I-131 travel document, in order to keep your adjustment of status pending. You don't need that. That's a huge benefit. All right, let's talk about the drawbacks of the H-1B visa right now. So drawback number 1, there is a lottery. So the H-1B is subject to an annual cap of 65,000 H-1B visas, plus an additional 20,000 for those with American master's degrees. You're probably not surprised to hear this, but the demand for these visas far exceeds the supply, so there's a random lottery. This year, 2026, is the first year they're changing how that lottery works. Those with a higher level wage have a higher chance of being selected than those with a lower level wage. However, it is still ultimately chance. Drawback number 2, there is a $100,000 fee. Under current rules from the Trump administration, if you are being hired from abroad, meaning you are not already in the US, and you have not successfully applied for a change of status, extension of status, or other type of qualifying application from inside the US before you left, you have to pay $100,000 in order to process your H-1B visa. Now, there are some limited exceptions. There is a national interest exemption, particularly if you're working in the healthcare field or other types of high-level manufacturing. I would consider doing this. Just personally, I have not had anyone successfully apply yet for the national interest exemption. Otherwise, this is going to be a huge deterrent. This is going to be the number one deterrent in not considering the H-1B as your non-immigrant path from abroad. Now, if you have a tourist visa or a student visa or other type of non-immigrant visa and you come to the US first and then apply for a change of status to H-1B once you are here and then leave the US to get an H-1B visa at an American consulate abroad, then you could essentially bypass that $100,000 fee. I'm not advising you to do that at all. I'm not advising you to do anything, but those are the facts. All right, drawback number 3 is timing. The H-1B lottery only happens once per year, happens in March. If you are selected, your visa doesn't become active until October 1st. So that really is a pretty long timeline to deal with. Now, there are cap-exempt institutions. If you work for certain nonprofits, government institutions, etc., you can get around the H-1B lottery. But even still, those cap exempt institutions are not exempt from the $100,000 fee either. So there are still other considerations for you to make if you are considering the H-1B. Again, the H-1B may still be a viable option, especially if you can find an employer who's willing to sponsor you and you can navigate the 2026, the modern fee structure. But compared to the O1 and L1, it's definitely more complicated and very likely more expensive and difficult than it otherwise was in times past. That's the truth. The last option, option number 4 that I would consider would be country-specific and investment visas. First, let's talk about the E1 and E2 treaty trader and treaty investors visas. So these visas are for nationals of countries that have qualifying treaties with the United States. Okay. The catch is, again, this is only available to certain nationalities. If your country does not have a treaty with the U.S., you cannot use these. I've mentioned this in previous videos. Some prominent countries that do not have these qualifying treaties are India, Brazil, China, among others. Also very important to note, e-visas are not dual intent. You're not supposed to have immigrant intent when you apply. So you should not have this. This can complicate your long-term green card strategy. The truth is, if you have this intent and you were to be asked this by a consular officer, hey, do you intend to return to our home country? Do you plan on applying for a green card? If you say yes, your underlying visa, the investment visa you're applying for, is almost certain to be denied. And this falls under a ground called 214B of the Immigration and Nationality Act. So immigrant intent is not allowed here. Now, if you were to apply for this visa fully with the intent to return to your home country, and then after you were to arrive to the U.S., that you subsequently changed your mind or circumstances changed, that you wanted to pursue adjustment of status, which does happen, that would be potentially acceptable. Let me explain why I keep on emphasizing dual intent. This is going to matter very, very much when you're processing your non-immigrant visa and once you're in the U.S., right? When you file for adjustment of status, this form I-485 I previously spoke about, you are telling the American government, I intend to become a permanent resident in the U.S. That's immigrant intent. Now, for most non-immigrant visas, think tourist visas, student visas, and most other employment visas, declaring immigrant intent can invalidate your underlying status. If your visa doesn't allow immigrant intent and you file for a green card, you may not be able to travel abroad until and unless that green card application is approved. If it is denied, you can jeopardize your underlying non-immigrant status. This is not a guarantee that underlying status will be revoked or denied, but there is an elevated potential that this can happen. Another consideration to keep in mind, when you leave the United States with a pending I-485, that application is by default considered abandoned unless you have one of the qualifying non-immigrant visas I previously mentioned, or you have advanced parole. This is an approved I-131 form that you would have filed with USCIS. And this is a travel document that allows you to depart and return with this pending adjustment of status. Now, there are also risks in using this advanced parole. If you use advanced parole to enter the US, your underlying visa status is often terminated. You will be considered to have entered as a parolee rather than the underlying non-immigrant visa that you had used to enter the US, right? And this means if your underlying adjustment of status does get denied, you may not have any status to fall back on. Again, one other thing I want to flag, especially in 2026, is that you should not come to the US with a tourist visa or a student visa explicitly with the intent to apply for adjustment of status. If there is a record of you having communicated this intent, whether that's on your phone, social media, or in any other aspect, and that communication were to be conveyed to USCIS or CBP or consular officers, not only will your underlying visa be denied, you could also be found inadmissible or deportable to the US by having committed fraud or misrepresentation. Especially in 2026, this is not a risk that anyone should be taking, nor is it ethically responsible to do so. One more thing I want to touch on are just the other green card pathways you can pursue once you're in the United States on a qualifying non-immigrant visa. Let's say you are able to obtain an O1, L1, H1B, or other qualifying non-immigrant visa. You're here in the US and you want to pursue a green card. There are a few paths for you to do this depending on your qualifications and relationships. Option number 1, a family-based I-130. If you have a U.S. citizen or permanent resident spouse, parent, child, or sibling, again, depending on the specific relationship, they may be able to file an I-130 petition for you. And then once this petition's approved and a visa number is available, you can apply for adjustment of status. Another option, employment-based I-140. If you have a U.S. employer who's willing and able to sponsor you for a permanent position, they can go through the labor certification process and file an I-140 petition for you. Alternatively, if you qualify for extraordinary ability or your work is going to be in the national interest of the United States, you may be able to self-petition independent of any company or employer. Option number 3, if you're making a substantial investment in a U.S. business that creates jobs, whether directly or through a targeted deployment area at a regional center, and you invest somewhere between $800,000 and $1.05 million right now, you may be able to qualify for an EB-5 investment visa. Lastly, option number 4 are special immigrants. So this would cover certain religious workers, broadcasters, certain translators who worked with the U.S. government from Afghanistan or Iraq, and other special categories. Special immigrant juveniles. This is also one that I have seen processed quite commonly in the past few years. All of these would file Form I-360, which is the petition that is used to obtain the immigrant visa, and then you file for adjustment of status once that's possible. In closing, what should you actually do right now? Check both visa freeze lists, right? So for the first list, make sure you familiarize yourself with the previous pause memo. There will be 39 countries that are there. There are countries that are subject to a full ban. There are 19 of them. And then there is a partial ban, and there are 39 listed there. The second list, of course, are those 75 countries that are listed on the visa freeze that was just announced on January 14th. Number 2, if you have an immigrant visa interview scheduled, make sure you attend that. Number 3, evaluate your non-immigrant visa options. Can you qualify for the O1 or the L1, H1B, any of these other qualifying non-immigrant visas? If so, start preparing your application for that. Of course, feel free to talk to an attorney or other qualified representative who can give you a real and legitimate assessment of your options. Number 4, if you're already in the U.S. on a visa, if I were you, I would stay put. I would not leave until you talk with an attorney or other qualified representative to make sure you fully understand the implications of your travel and that you can accept any elevated risk in international travel right now. I just want to say in closing, I really don't think this is the end of the American dream. If nothing else, this is just a detour. The whole purpose of these updated security measures is to make sure that people are obeying the law, that really the people who are coming here to the U.S. are contributing to the welfare of the American people and of this nation. I'm going to continue to stay on top of this. When there are updates, when policies change, when there's new guidance, I will post a video, try to keep everyone apprised. If you found this video helpful, of course, feel free to hit that like button. It helps more people find this video. Yeah, feel free to drop your questions in the comments. I do read every single one. If you need personalized help, feel free to click our consultation link. If not, no pressure at all. And see you next time.